Hello everyone, welcome back to Constitutional Law Lecture Series. Today we will continue our discussion on Article 19. So in the last lecture we had an overview of Article 19, but in this lecture we will be talking about Article 19 Clause 1 Subclause A. ठीक है? So we know that Article 19 Clause 1 offers us six kind of rights, that is freedom of speech and expression. Then we have to assemble peacefully without arm, and then to form association, unions, and also cooperative society. Fourth one is to move freely throughout the territory of India. Fifth one is to reside and settle in any part of India. And the last one is that is to have occupation, profession, trade and business of our own choice. ठीक है? So these are the rights which Article 19 Clause 1 offers to us. Today we will be talking more about Article 19 Clause 1 Subclause A, that is freedom of speech and expression. ठीक है? But before starting that topic, firstly I want to address this concept, that is concept of reasonable restriction. What is reasonable restriction? Because this whole Article 19 is subject to reasonable restriction. That's why it is important for us to understand this. Okay. Now, so it's very interesting that if you go to the original constitution, you will not find this word of reasonable, ठीक है, in Article 19 Clause 2. That is, the word reasonable restriction is only there in Article 19 Clause 3, 19 Clause 4, 19 Clause 5, 19 Clause 6, but not there in 19 Clause 2. There only restriction is written, reasonable is not written. ठीक है? Now what happened? By first Constitutional Amendment Act of 1951, this word reasonable was added even in Article 19 Clause 2. So after 1951, the situation is for all the clauses, 19 Clause 2, 19 Clause 3, 4, 5, 6, in all the clauses we have this word reasonable restriction. Now the problem is we do not have a definite meaning of reasonable restriction. ठीक है? The thing is, we know what is restriction. So according to the Constitution of India and according to Article 19, restriction must be reasonable, the first one, and restriction must be on the grounds which are mentioned in Article 19 Clause 2, 3, 4, 5, 6. So if you see Article 19, in different clauses, different grounds are mentioned as as the basis of putting some kind of imposition on these rights. So for example, for freedom of speech and expression, we have grounds like in the interest of unity and integrity of the nation, and then friendly relation with foreign state, then decency, morality, public order, defamation, contempt of court. So on these grounds, imposition of some restrictions can be made, some restrictions can be imposed on these grounds for Article 19 Clause 1 Subclause A. And for Subclause B, Subclause C, Subclause D, E, F, we have different grounds. Now, restriction shall be reasonable and related to these grounds only. But the question is, what is reasonable? Who will define what is reasonable? Because in law, we have definite meaning of almost all the words. So if an act is mentioning some word in any part of that act, that word should be defined in the definition part. But the problem with this reasonableness is it is nowhere defined in any of the act in India. So Supreme Court took this task of defining what is reasonableness, and in many cases we saw that on the basis of many principles the reasonableness was decided. And one of such principle among many is that the reasonableness demands proportionality, and it is related to doctrine of proportionality, which means that whatever is the limitation, whatever is the restriction imposed by the state shall strike a proper balance between the freedoms guaranteed under Article 19(1) and the social control permitted under Article 19 Clause 2. ठीक है, सो देयर शुड बी बैलेंस बिटवीन दोज कि जितना हमको रिस्ट्रिक्शन है, जितना रिस्ट्रिक्शन लगा है दैट इज वैलिड. ओके, ऑल्सो द reasonableness also amounts to like it should be reasonable substantially also and procedurally also. So whatever law is there, it should be reasonable in substantive way also as well as procedural way also. And then reasonableness as an objective concept. So Supreme Court has said that the reasonableness of any restriction or limitation that is imposed by the state has to be determined in an objective manner. ठीक है, and from the viewpoint of the society and from the viewpoint of the interest of the community rather than the point from the viewpoint of an individual. So these are some of the principles which Supreme Court has established when to ascertain whether this restriction is reasonable or not. Okay. Now coming to Article 19 Clause 1 Clause A, which is freedom of speech and expression. ठीक है? So what is this freedom of speech and expression? Now the thing is, see, India is a democratic country and we all know that for a good democratic country, it is very important that the citizen of that country should have voice. Voice as mean ये audio नहीं. Voice mean they should have this opportunity, they should have this facility to express their opinion openly without the fear of any other negative repercussion. ठीक है? So for a good democracy, it is very essential that such kind of freedom of speech and expression shall be granted to its citizen, that country's citizen. Now, for the first time, this article was challenged in the case of Ramesh Thapar versus State of Madras, that what is included in freedom of speech and expression. Because unlike the Constitution of America, Indian Constitution does not specifically include freedom of press in freedom of speech and expression. So the question before the Supreme Court of India in Ramesh Thapar versus State of Madras was that whether freedom of press is also included in freedom of speech and expression or not. So here the Supreme Court said, and that too Chief Justice Patanjali Sastry said, that freedom of speech and of press lay down the foundation of all democracy. ठीक है? And without free political discussion, no public education, so essential for the proper functioning of the process of the popular government, is possible. This is the statement of Justice Patanjali Sastry, that he is saying that this kind of freedom of expression is essential for maintaining democracy. Understanding? And in the next case, so we have many cases in row where different kind of speech and expressions were challenged in the court, and Supreme Court answered whether Article 19 Clause 1 Subclause A includes such kind of thing or not. For example, broadcasting. ठीक है? For example, commercial speech, advertisement, press तो है ही है. So many things were asked from the Supreme Court कि बताओ भाई ये freedom of speech of expression है कि नहीं. So, in the case of Brij Bhushan versus State of Delhi, the Supreme Court struck down a order, that is Section 7 Clause 1 East Punjab Safety Act 1950, which directed the editor and publisher of a newspaper to submit for scrutiny all the articles, all the newses to the state before publishing it. ठीक है? So such kind of order was struck down by the Supreme Court, holding that this comes as a pre-censorship which is violating Article 19 Clause 1 Clause A. ठीक है? Then in the Romesh Thapar case, I can say it's the first case on Article 19 of the Constitution of India. And what happened in this case? That is, state of Mysore banned the circulation, or forget about circulation, even entry of this newspaper Crossroad, and this was challenged in the Supreme Court by the state of Bombay and this newspaper organization. So what the Supreme Court is saying? The Supreme Court is saying that freedom of speech and expression includes freedom of propagation of ideas, and this propagation of ideas is ensured by the freedom of circulation. So, what if you are allowing someone to print, to write anything, but if there is no circulation, that how such right can be effectively, the right of freedom of expression and speech, how this right can be effectively used if you do not have right of circulation. So this was held by the Supreme Court of India in Romesh Thapar case, that freedom of press includes freedom of circulation also. So the order of the state of Mysore government to ban the entry and stop the circulation of this particular newspaper is invalid. ठीक है? Now in Sakal Paper Private Limited versus Union of India, a order of government was challenged, and the name of the order is Daily Newspaper Price and Pages Order 1960. ठीक है? Actually, this order fixed the number of pages in a newspaper and also raised the price. So, for example, if you want to print 10 pages, so you have to pay 100 rupees, hypothetically. If you want to publish 500 pages, then you have to give us 1000 rupees, like this. Now this order was again challenged in the Supreme Court. Now what petitioner is saying? The petitioner is saying that the order affected the liberty of the press, the freedom of the press, because because you have to face one of the situation. Either you have to limit your article within few page, or you have to pay extra fees to the state government. And state on the other hand is saying that the law is justified as a reasonable restriction on the business activity of the newspaper in the interest of general public. ठीक है? Now if you remember, Article 19 Clause 2 has grounds, and on the basis of those grounds you can surely put reasonable restriction on Article 19 Clause 1 Subclause A, that is freedom of speech and expression. But those grounds do not include general public. ठीक है? ये जो general public वाला ground है, that is in Article 19 Clause 6, and which is for 19 Clause 1 Clause G, Subclause G. So Supreme Court is saying that if the state wants to put some restriction or limitation on the ground that it is in the interest of general public, that then it is invalid, because a state can impose only such reasonable restrictions which are based on those grounds which is in Article 19 Clause 2, and their general public, in the interest of general public, is not mentioned. ठीक है? So this order was struck down by the Supreme Court of India. Then we have another case, that is Bennett Coleman versus Union of India. What policy for newsprint for 1972 to 1973, along with newsprint control order that was issued under Section 3 of Essential Commodities Act of 1955, was challenged. So what were the three main objectionable provision in this order? The first one is bar on starting new newspaper or edition by common ownership. The second provision was rigid limitation of 10 pages. ठीक है? The third was bar on interchangeability within common ownership unit, and the fourth was allowance of 20% page increase only to newspaper having below 10 pages. So with these four kind of provision, the state imposed some kind of limitation on newspaper. ठीक है? So the court struck down this order and this policy and held that this is against Article 19 clause 1 subclause A, because if you limit the page of a newspaper, so in a way you are violating freedom of speech and expression. So that's why it was struck down. Then, in another case law, Supreme Court was asked whether commercial advertisement will come under freedom of speech or expression. So, the journey is like earlier commercial advertisement were considered as part of Article 19 Clause 1 Subclause G, that is trade, business, occupation, profession. But Supreme Court shifted its instance, and in the case of Tata Press Limited versus MTNL, the year is 1995, Supreme Court held that commercial speech is also a part of freedom of speech and expression guaranteed by Article 19 Clause 1 Subclause A. ठीक है? So these advertisement which we see, the hoardings which we see, and any kind of this on YouTube we see many kind of ads. So these all are part of freedom of speech and expression. The next case is what is demonstration. So in the case of Kameshwar Prasad versus State of Bihar, year 1962, Supreme Court said that demonstrations being visual representation of ideas will also be protected by Article 19 Clause 1 Clause A. ठीक है? But the Supreme Court said that there is a difference between hartal and band. You know na hartal and band? So we have some strike and total band means आज पूरा भारत बंद रहेगा, आज पूरा बॉम्बे बंद रहेगा. So we have some kind of strikes like this. So the Supreme Court is saying that there is a difference between hartal and band, and the constitution gives you the permission of hartal, strike, but not of band. You cannot declare that on this and this date there will be band. So this was the position of Supreme Court in those years. Now in K.A. Abbas versus Union of India, Supreme Court was asked about the constitutionality of the censorship, not censorship but pre-censorship of the films, which is also a media of communication, media of expression. So whether pre-censorship on films is not violative of Article 19 Clause 1A. This was asked by the director of a movie, and the movie name was Tale of Four Cities. Actually, what happened that this film did not get U certificate. So for any film, we have these two certificates, U certificate and A certificate. A certificate means adult movie, U certificate means universal movie. So the moment your movie is getting A certificate, adult movie, it means that people who are below 18 years of age cannot watch your movie. ठीक है? So a good section of your audience is getting prohibited to watch the movie. So this director approached the Supreme Court and asked whether this kind of pre-censorship is against Article 19 Clause 1 Subclause A or not. Now the Supreme Court is saying that the censorship of film, including pre-censorship, was constitutionally valid in India as it is a reasonable restriction within the ambit of Article 19 Clause 2. ठीक है? And this was pointed out by the Supreme Court that pre-censorship was an aspect of censorship only, and the court went to the extent of laying some guidelines for the censors For example, the sex and obscenity are not always synonyms. ठीक है? And it is wrong to classify sex as essentially obscene or even indecent or immoral. So, Supreme Court said that this restriction, pre-censorship on this movie is very much within the constitutional limit. ठीक है? Now, in another case, Rangarajan versus P. Jagjeevan Ram, the Madras High Court revoked. Then we have the case of Maneka Gandhi versus Union of India, where the constitutionality of Passport Act 1967 was challenged. Now, what happened in this case? The petitioner, Maneka Gandhi, was a journalist and her passport was confiscated and she was not allowed by the authorities to go abroad. ठीक है? So she went to the Supreme Court and asked that whether my Article 19 clause 1 has been violated or not, because I have been restricted to go to abroad. Now the Supreme Court is saying that right to go abroad was not included in Article 19 clause 1. ठीक है? So Article 19 clause 1 gives you to move freely throughout the territory of India, within the territory of India. Going abroad is not covered under Article 19 clause 1. ठीक है? Then we have another case, that is Anand Vardhan Chandel versus University of Delhi. In this case, the Supreme Court held that freedom of speech and expression under Article 19 clause 1 subclause A includes right to education. Wonderful. ठीक है? But it is wonderful, at the same time it is chaotic. Because the moment Supreme Court will declare that we all have right to education, obviously everybody will knock the door of schools and educational institution to give admission, and the state has no such capacity to ensure right to education to everyone. So immediately, this stance of Supreme Court was clarified in another case in the very next year, that is in the case of Unni Krishnan versus State of Andhra Pradesh, and it was held by the Supreme Court that right to impart and not right to receive education is a fundamental right. So right to impart means it will come under Article 19 clause 1 subclause G, that is freedom of trade, trade, occupation, profession, business. So right to impart education is a fundamental right, not right to receive education. ठीक है? So this was clarified in the case of Unni Krishnan versus State of Andhra Pradesh, and this was again reiterated in TM Pai Foundation versus State of Karnataka, that right to impart education is a fundamental right. Then the Supreme Court has also said in the case of SP Gupta versus Union of India, year 1981, that the right to know, ठीक है, receive and impart information is also fundamental right under Article 19 clause 1 subclause A. Then in the case of Prabha Dutt versus Union of India, the Supreme Court directed the superintendent of Tihar jail to allow some newspaper representatives to take interview of two of the convicts of Tihar jail. So Supreme Court said that such kind of thing, that is taking interview, is also covered by Article 19 clause 1 clause A, but Supreme Court clarified this also and made this observation also, that Article 19 clause 1 subclause A is not absolute right and it cannot be given unrestricted. But Supreme Court ordered the superintendent of that Tihar jail to allow newspaper representatives to take the interview of two convicts. ठीक है? And then in the case of Munna Bhai D. Shah versus LIC, Supreme Court said that the right to reply is also a fundamental right. That is, right to get published one's reply in the same news media in which something is published against the same person or in relation to a person has been recognized. ठीक है, that if something is published against you in a particular paper, you have a right to reply in that particular paper only, and it is covered by article 19 clause 1 subclause a. It was held by Supreme Court of India. There are many case laws for article 19, trying to cover as much as I can. Okay. Then Supreme Court has also said that right to freedom of speech and expression also includes right to remain silent. ठीक है, तो ये भी हमारा fundamental right है. Then in case of Odyssey Communication Private Limited, year is 1988, Supreme Court has said that the right of a citizen to use electronic media such as exhibition of film on Doordarshan is also covered under Article 19 Clause 1 Clause A. Then in Shreya Shingal versus Union of India, the year is 2015, Supreme Court of India struck down and held unconstitutional Section 66A of Information and Technology Act, saying that any law seeking to impose a restriction on the freedom of speech can only pass if it is related to those 8 grounds which are there in Article 19 Clause 2. Okay? So it is not like on any ground you can put restriction on freedom of speech and expression. Supreme Court is again clarifying in this case of Shreya Singhal that restriction can be put only on those 8 grounds which are there in Article 19 Clause 2. Okay? Then in one case, that is People's Union for Civil Liberties and Union of India, year is 1997, Supreme Court is saying that telephone is also a means of expression. ठीक है? So telephone taping, unless it comes within the grounds of restriction mentioned in Article 19 Clause 2, is violative of your fundamental right of freedom of speech and expression. Understood? Then Supreme Court is also saying that nota, that is none of the above, not to. Then Supreme Court is saying that the right of the voter to choose nota, okay, that is none of the above, is also covered by Article 19 Clause 1 subclause A. ठीक है? Then Supreme Court is saying that right to fly national flag freely with respect and dignity is also included in Article 19 Clause 1 Clause A because it is expression. But the Supreme Court clarified that such practices of burning flag, as we have seen in USA, is not permitted in India. Such expressions are not allowed. Then Supreme Court has also said that gender identity is also covered by Article 19 Clause 1 subclause A because it has been recognized as an aspect of expression. ठीक है? So dealing with the issue of transgenders, the court held that values. So this was about Article 19 Clause 1 subclause A, freedom of speech and expression. There are many articles in this. I just tried to cover as many as I can, and if time permits, I will make another video also on this article only and will include other case laws also. So at least for exam purpose, you can proceed with this. Thank you everyone.